while we wait for the others to join, let me just introduce myself. My name is Bashir Ibrahim. For those who don't know me or haven't worked with me before, I am a commercial lawyer here at Legalese, and I also am in charge of the wills service product offering that we offer now at Legalese. Yeah, I feel very passionate here about having a will in place because, well, anything can happen. The twist and turn can happen at any minute, and you find yourself in a situation that could have been easily remedied if you had the necessary in place. So yeah, I'm just going to chat to you about, like I said, the ins and outs of why I should have a will, the requirements for a will, and what happens if you don't have a will. Yeah, let's just wait another minute, and then we can get stuck in. Cool. Okay, cool. Let's just get started. You can just join in, if you relate, it's fine, no worries. Load shedding keeps us all, so that's why we are a little bit late for the webinar today, so I apologize for that. But let's discuss what we're going to cover today. So we're going to cover what a will is. What is a will? Why do you need one? What happens if you don't have a valid will in place? What makes a will valid, and what the requirements are for a valid will in terms of the Wills Act. Can you e-sign a will? Are electronic wills valid in South Africa? And any other requirements and legalities that you should be aware of before you obviously execute your will. Okay, cool. So what is a will? A will is basically a form signed written document, and the most basic definition of a will, or otherwise known as a last will and testament, is that it is a form signed written document in which a testator voluntarily sets out his or her or their instructions in an unambiguous manner as to how the assets should evolve upon their death and who it should go to. If we could just expand on the definition, a will allows a testator to dispose of the whole or any part of their assets as they please. It gives effect to your wishes, as long as it's not contrary to like the morals and the morals of society, basically. What that means is something can be legal in that it's not infringing on anyone else's right, but society may deem it to be immoral. Therefore, it won't necessarily be something that is allowed. So an example of that is back in the day, only men could inherit because that was the law. But now it's not the case anymore because the law has changed, and that's an example of a law that would be immoral to us now. But back then, it wasn't immoral for only men to inherit from their parents' estate or family members' estate. Another point is that you can appoint your heirs or your legatees or any substitutes for your estate. So there's a difference between an heir and a legatee. An heir is someone who's able to inherit from the person via intestate or testate succession. And a legatee is only someone who will be able to inherit in terms of a valid will. So if it's not possible for a legatee to exist if the person died intestate. Example of that would be a friend. You can leave items to a friend, you can leave items to a neighbor, you can leave items to your colleagues or your boss, whatever the case may be, but they wouldn't be considered an heir in terms of intestate succession should you die without a will. You can create trusts, you can appoint trustees for your trusts, and you can appoint your administrators who can and also regulate their power in terms of those appointments. You get to choose your executors, you get to nominate guardians for minor kids, and you can even make a will without naming any beneficiaries, such as one where a previous will was revoked and an executor is appointed or an heir is disinherited. So like what that means is previously you had an heir, you had heirs in your old will. Now your new will basically says, well, I'm giving everything to charity. It's also very important to note that even though the topic of a will has been discussed ad nauseum, I mean, everywhere you go, there's something about the will online. There's also a lot of videos about wills online. There is still a large portion of the South African population that does not have a will in place. And this is scary because what this means is in the state and the laws of the state will then effectively take over your deceased estate. And it's not an ideal situation to find yourself in to leave your estate in the hands of an already overburdened system. So yeah, this is the reason why we're going to delve into this today. But more on that in a few minutes. Why do you need a valid will? So your will ensures that your assets and personal possessions are divided up amongst those individuals you want to inherit from your estate. Without a legally valid document setting this out, your estate won't necessarily like bequeathed according to your wishes. It's going to go according to the laws of interstate succession, which we will discuss later on in this webinar. And it's a way that you can protect your loved ones and your businesses a lot this way, because you don't want your estate to fall into the hands of someone who is not necessarily deserving of it, for lack of a better word. And basically anyone can execute a will as long as the requirements in terms of the Wills Act are followed. We'll also look at those requirements later in the webinar. Okay, let's look at what happens if we don't have a will by the time that you pass. So, like we've discussed, the will ensures that your assets and personal possessions are divided up amongst those individuals that you want to inherit from your estate without a legally valid will that's setting out this arrangement. Your estate is going to be devolved according to the Interstate Succession Act. This means that your estate will be divided amongst your surviving spouse, your children, your siblings, etc. And it's all according to a set formula. So if you can see, there's a nice little diagram that I've included here for you to have a look at. This is deceased, you first got your spouse, then whatever is left over got to, like, if it's in community of property, 50% go to your spouse, other 50% is going to go to your children, grandchildren, great-grandchildren. If you have none of those, it's going to go to your parents, your siblings, and then your nieces and nephews. If you have none of those, then it's going to go to your grandparents, your aunts and uncles, your cousins. And if you have none of those, we'll talk about that in a minute. Yeah, like I said, it's all according to a set formula in the Act. All estates will be distributed in terms of the Act. Okay, sorry to mention it again. This means that the beneficiaries in order of preference are the spouse, the descendants of the deceased person, your parents, only if the person died without surviving spouse or out any descendants, like your children and your grandchildren. The siblings of the deceased, only if one or both parents are deceased. And another thing to note is that the Interstate Succession Act should be read in a way that it accommodates cases where the deceased was a husband in a polygamous customary marriage union. This is obviously decided in a very impactful and influential case of Bay. Sorry if I'm not pronouncing that correctly. When the deceased is also left with no spouses, no descendants, the wives then of a polygamous marriage will inherit the estate in equal shares. This is only in the case of a polygamous marriage. And when the deceased has left spouses and descendants, the spouses and descendants will inherit the estate in equal shares, but each wife should inherit at least 250,000 rand. When the estate is not large enough for each wife to inherit, then the 250,000, then the spouses will inherit whatever is left in equal shares, while the descendants will not receive anything. So that is the whole premise of the Bay case and polygamous marriages, and how your estate will devolve if you are in a polygamous marriage. But in case of like a normal, like not normal, sorry, in case of like a person who is married to one person only, this is the route that you're going to take, which is the spouse, children, with none of that, and the parents, siblings, nieces, nephews, with none of that, grandparents, aunts, uncles, etc. Okay, let's talk about the consequences of that come with having your estate devolve interstate according to the Interstate Succession Act. Firstly, your estate could go to family members that you would not have left anything to in the first place, so they would unduly be benefiting unduly. So, like if you had a fight with, or falling out with a family member, they are estranged, you don't talk, you haven't spoken in 20 years, they would ordinary benefit under the law. But if you had a will, you wouldn't necessarily leave something to them. Your assets that are left to minors, very important point to pay attention to, will be placed in the guardian's fund until they turn 18. The guardian's fund falls under the administration of the master of the High Court. And this structure was initially intended to, was set up with the intention to safeguard and administer the inheritance of obviously our country's most vulnerable, which is the elderly, children, etc. And we all know that may be amazing theory, but it is unfortunately one of those funds that are falling short of its mandate. It receives over R1 billion each year, which should go to beneficiaries, but it's so poorly handled with a lot of red tape procedures that must be followed before anything goes to the children. And think about the fraud and maladministration that has happened in the past. You know, that's why it's not an ideal situation for your children's assets to go into the hands of the state. And that is what's going to happen if you have no will. Another thing regarding the minor children is guardianship. When a parent dies, the surviving parent will automatically become the legal guardian. But what about those instances where both parents are no longer alive? Who gets legal guardianship of the children or the child? The state will then step in and appoint a guardian for the child, which again is hardly the best solution in this instance. Your will basically enables you to appoint a guardian of your choice, and as well as an alternative guardian, to make sure that the most appropriate person is chosen to take care of your minor children as the legal guardian. But without a will, you don't get a say in that. In terms of your executorship, you, like I said, with your will, you get to choose your executor. But without one, the state will appoint an executor to wind up your estate. And this could be a complete stranger with little to no understanding of you, your family dynamics, your wishes, etc., and your personal circumstances. So that executive that gets nominated and appointed may not be acting in the best interests of, your family or even you after death. So if you, I'm not sure how rare this is anymore, but if you're a person and you die with absolutely no heirs, in that you have no spouse, you have no kids, no grandkids, no parents, no siblings, no grandparents, no uncles, aunts, cousins, nephews, nothing, and you die without a will, your assets will then be forfeited to the state and be placed in the guardian's fund for safekeeping for a period of 30 years. And if no heirs step forward in those 30 years to claim the inheritance, then the assets will effectively become the property of the state. So that's why it's important to have a will. Another one to take note of, another consequence, is the distribution of immovable property in the event of an interstate death can result in estate planning problems. So an example of this is a deceased is married in community of property, leaves behind a spouse and 2 or 3 minor children who live in that house and that is their primary residence. The deceased share of the joint estate will be the share that's distributed amongst the surviving spouse and the children. And if the surviving spouse needs to sell the property for whatever reason, she will need permission from the master who will then act on behalf of the minor children. And similarly, where fixed property is inherited by multiple heirs, it may be difficult for the heirs to reach an agreement on how that asset should be dealt with. And this can cause unnecessary delays in the estate administration and just take so much longer to wind up and finalize. Whereas your will nicely indicate what you want done with your property and hopefully, allow for a smoother transition after your death. If you have any foreign assets, it's vital that you draft a foreign will as well as a normal South African will to deal with your assets in the event of your death. Many civil law jurisdictions have what is referred to as forced heirship rules, which provide inheritance rights to family members. So generally speaking, a South African will cannot override the rights of family members to inherit in terms of a jurisdiction's mandatory succession rights. So what this means is that even without South African will, your foreign assets also need to be regulated with a foreign will. Otherwise, you are at mercy of that jurisdiction's laws pertaining to inheritance. And another consequence of interstate succession is that estate duties and taxes are usually structured when you're doing estate planning. It can be done in a way that is effective to reduce both estate duty and taxes. And on the other hand, an estate that is wound up according to the law of interstate succession will not be able to benefit from the structure. And this could also result in cash shortfalls in the estate, which could in turn lead to assets having to be sold off to cover that shortfall. So it's a lot to consider there. It's a mouthful, but do your research beforehand so that you're clued up and you have a better understanding of why this simple document is one of the most important documents you will ever have in your life. Okay, cool. Then let's look at what are the requirements for a valid will. So, Section 4 of the Wills Act states that every person of the age of 16 years or more may make a will, unless at the time of making the will, they are mentally incapable of appreciating the nature and effect of the act, and the burden of proof that they were mentally incapable at the time shall rest on the person alleging the same. So what this means is anyone can make a will as long as you're 16 years and older and you have the requisite mental capacity to execute and draft and execute one. So before discussing the requirements of a valid will, I just basically said that. So that is kind of the 16 years and older is kind of in stark contrast to the age that a witness needs to be if they're witnessing your will. You have to be 16 years and older to make a will, but you have to be 14 years and older to be able to sign a will, which is a bit strange, but that is the law. Section 2 of the Act describes a number of formalities that need to be followed when executing a valid will. That is, the will must be signed by the testator or any other person in their presence and by their direction. The signature must be made in the presence of 2 or more competent witnesses at the same time. Very important, because you cannot sign your will now and then in 2 hours time be like, oh, just witness my will. It needs to happen at the same time. The witnesses and the testator must be in the same room when the will is being signed. Witnesses must attest and assign the will in the presence of the testator, in the presence of the testator, as well as in the presence of other witnesses. And when applicable, the person who has signed the will and testator's presence and by the direction. If the will consists of more than one page, each page must be signed by the testator or the person who's signing on behalf of the testator. Preferably, while the act says anywhere on the page, it's preferable, it's better to sign close to the last line of the will, of that page, sorry. If a will is signed by a testator by making a mark or by some other reason, some other person in the presence and by the direction of the testator, a commissioner of oaths must certify that they are satisfied with the identity of the testator and that it was signed by the testator giving direction. Sorry, it was signed by someone else on behalf of the testator at their direction. Basically, your commissioner of oaths must just attest to the fact that if I'm using a third party, like I'm using a friend or a brother or sister to sign on behalf of me, it was done in my presence, it was done in the presence of witnesses, and I actually did give that direction. So yeah, that's the requirements for drafting a will. You must be 16 years and older, you must have the mental capacity to do so. It must be written and signed in the presence of 2 more witnesses. And if you have someone else signing on your behalf, it must be commissioned by a commissioner of oaths. These requirements also apply to the amendments that you make to your will in the form of codicil. Again, 16 years and older, mental capacity, signed by the testator in the presence of 2 more wills, etc. Cool. Let's look at whether you can e-sign a will. So we live in a digital age, of course. We are moving more and more and more away from paper and more towards digital every single day. And also because of the most recent pandemic that we've had, still have, COVID-19, it really highlighted the question of whether we can sign a will electronically. But basically, let's first look at what constitutes an electronic signature and whether this will meet the requirements as set out in Section 2 of the Wills Act. So Section 2 of the Wills Act, we just discussed, sets out all the formalities in which the will must for you to follow in order for the will to be valid. And the Wills Act also defines further that a signature includes the making of initials as well as making a mark. The Wills Act doesn't specifically provide for the electronic signature of a will. So if you either can physically sign your signature or you can put your initials, or if you are illiterate, you can make a mark in the form of like an X or a circle or a tick or whatever the case may be. But there's also rules around that. But for the purposes of today, we're just going to focus on signature, initials, and a mark. And in terms of Section 1 of the Electronic Communications and Transactions Act, an electronic signature means any data attached to, incorporated in, or logically associated with other data, and which is intended by the user to serve as a signature. The ACTA, however, differentiates between an advanced electronic signature and a standard electronic signature. And where signature is required by law, it provides that an advanced electronic signature must be utilized, and there's further requirements for that as well. So what an advanced electronic signature in this circumstance is that it is basically a standard electronic signature which has been accredited in terms of Section 77 of ACTA by a recognized accreditation authority. A standard electronic signature includes digital or scanned signatures. It has been argued that the standard electronic signature suffices where the signature is required by the party to an agreement, and they do not specify the type of electronic signature that is needed. The ACTA basically provides the electronic signature will be deemed to be valid where a method is used to identify the signatory and having regard to all the relevant circumstances at the time, The method was as reliable as was appropriate for the purposes for which the signature was utilized. And if we look at this in comparison to the Wills Act, the use of electronic signature does not meet the requirements for a signature in terms of, doesn't in terms of the Wills Act. And there is a need for the legislature to consider amending the Wills Act to provide for electronic signatures of wills, provided that an advanced electronic signature is used. So right now, it's still very much old school, hard copies, go print your will and then sign it in the presence of 2 or more witnesses, because e-signatures are not recognized. They don't fall within the ambit of Wills Act. That's all you really need to take away from that right now. And if, say you've now signed a will using an electronic signature and you were unaware of the requirements in terms of the Wills Act, there is a section in the Wills Act that allows for these instances where the formalities for the signature of a will have not been met. And it's in terms of section 2.3 of the Wills Act. And it states that it's possible for a court to declare that the document be accepted as the will of the deceased if a court is satisfied that a document or the amendment has been drafted or executed by a person and has since died. And when doing so, he intended for this to be his will before death. Basically, a will that is drafted electronically can be regarded as a validly executed will if an application is made to the High Court and the High Court is satisfied that the document was drafted by the deceased, B, the deceased has died since drafting the document, and C, the document was intended by the deceased to be his last will. But there's no real legal certainty as to how and when electronic data can be used for the purpose of conveying that this is your final will. So until that has been, established and, amended in terms of the law or not amended in terms of the law, it's best to just do it the old-fashioned way. Print your will, have a hard copy, etc. So, yeah. Let's look at whether electronic wills are valid. So in terms of section 4, 4 of the ACTA, there's basically a prohibition that says you cannot draft the will. It won't be considered as valid. More specifically, this section says that the act must not be construed as given validity to any transaction mentioned in Schedule 2. And Schedule 2 specifically says that the execution, retention, and presentation of a will or codicil as defined as the Wills Act. Therefore, it wouldn't be a valid will in that manner. So once again, old-fashioned way, hard copies. The law, unfortunately, needs to evolve and keep up with the times, but until then, protect yourself. Don't do it on the computer. I mean, you can type it on the computer, but it needs to be printed. You can't type it and then just store it on the computer and then e-sign. No, that's not, you will run into problems with that. Okay, cool. Let's talk about any other legalities regarding a will. So the following points that I'm putting forward are best practice and won't affect the validity of your will per se, but it should be remembered when you're executing your will. So one, well, date your will so you'll avoid confusion, especially if you have multiple copies. There have been many instances where someone thinks they found the will and another person thinks they found the will, and then they want to contest the will and has to go to High Court, and the court has to make a ruling on it, except which one is the right one. So date your wills. A witness cannot benefit under a will. So if they've been nominated as an heir or a beneficiary, they cannot sign your will. They will not be able to inherit if that is the case. Your witnesses cannot be nominated as an executor, administrator, trustee, or guardian. It needs to be completely different people. Otherwise, it will be void. Your witnesses, as well as yourself, as a testator, must sign every page or initial every page of your will. So in the flip side of that, number your pages as well. Your will must be clear, readable, printed or handwritten, and as unambiguous as possible. Because the minute you are all vague and whatnot, you're gonna have trouble. Your loved ones and the master's gonna have trouble deciphering what it is that you want here. Signatures must be as close to the last line of every page. I've discussed it already. Number your pages, discussed it already. And also, I always tell people to keep more than one original copy of your will. So don't just print one copy and sign it and that's it. And then you make copies from an original. Print 3 copies. Sign all 3 copies as original. Keep one yourself. Give 1 or 2 of them, depending on how many you print, to close and trusted family, so that if anything should happen to you, they don't have to scramble around looking for your will, trying to figure out whether you have one or not. They already have it and they can access it easily, just to make their lives a little bit easier after your death. And amend your will regularly to accommodate those milestones in your life, like, marriage, divorce, children, acquiring new property and assets, etc. Factor that into your will. Don't just, draft a will today, one and done, move on, forget about it. But then some big things happen in your life and it's not accounted for. Your loved ones and your property, they're gonna bear the brunt of that decision later on. Yeah, so that's just me on my webinar today, chatting very briefly about why I must have a will, what makes a will valid, what happens if you don't have a will, the consequences of that, can you e-sign a will, can you have electronic will, etc. So yeah, like I promised in the beginning, nice and short. If you have any questions, then you can always pop me an email, you can always give us a call, and I'd be happy to answer your questions for you. But yeah, that concludes today's webinar. Thank you so much for joining us. I hope that I was able to shed some light on wills, even though I know there's a lot of information online. I'm never going to stop hammering home this point. Get a will. Cool. Have a good day.